property with the existing non-conforming borough pit to be located on a certain parcel of land lying and being in Lewis and Rehoboth 100, Sussex County, containing 50.90 acres more or less. The property is lying on the southwest side of Plantations Road, which is Route 1D, approximately 0.18 miles southeast of Robinsonville Road, which is Sussex County Route 277. The 911 address is 33508 Ritter Lake Road, Lewis, and tax parcel ID is District 334, Map 12, Parcel 7.00. Submitted into the record, Mr. Chairman, we have a copy of the applicant's exhibit booklet, a copy of the applicant's conceptual site plan, a copy of the staff analysis, we have a copy of the DNREC DENREC inspection report, we have a copy of a letter received from the Sussex County Engineering Department, Utility Planning Division, we have a copy of the DELDOT Service Level Evaluation Response, we have received a petition with a total of 36 signatures in opposition to the application, we have received a total of 30 written responses in opposition to the application, although I'd note that some appear to be duplicates, and in total we received 42 letters in support of the application and 5 mail returns, although I would note, Mr. Chairman, that some of those do appear to be duplicates, by the same person sending the same letter to multiple locations. Okay. Thank you.
All right, thank you. Mr. Chair recognizes Mr. Hutt.
Thank you, Chairman Wheatley. Good evening, members of the Planning Commission, county staff, and council. For the record, my name is David Hutt, a local attorney here in Georgetown with the law firm of Morris James. This evening I am representing Howard L. Ritter & Sons, Inc., the owners of the property, as well as the applicant for tonight's conditional use application. With me this evening, and there's several of them, but I'm just going to limit myself to 2 of the principals of Howard L. Ritter & Sons, Inc., and they're sitting to my left and your right, Ronnie Ritter and Susan Ritter, and then the gentleman sitting to my right and your left is somebody you're familiar with, Mark Davidson, Vice President and Principal Land Planner with Pannoni. As the application was just introduced by Mr. Whitehouse a moment ago, this is an application for a conditional use to allow the continued sale and storage of things like stone, mulch, soil, and related outdoor products. And I'm going to, for the ease of not having to say that phrase over and over again this evening, I'm just going to refer to those generally as landscaping materials. And as I think everyone is familiar, this property is situated just off of Plantations Road. There is an existing, pre-existing non-conforming borrow pit on the property. And as you'll hear as I present this application tonight, historically, the property has had the sale of these outdoor or landscaping materials throughout the history of the Ritter use of the property. I wanted to begin tonight, and hopefully this puts most people's minds at ease this evening as I begin, but I wanted to begin by explaining first what this application is not, and hopefully debunking some of the misinformation that has been spread about this application. Most importantly, this application is not an application seeking to allow concrete crushing or the grinding of trees and stumps or dyeing of those products to create a mulch product. At one time, these were part of the application, but after careful consideration of this matter, the Ritters amended their application and removed the grinding, shredding, dyeing of those things. So that is not part of this evening's application.
And also remove the concrete crushing as well?
That is correct.
Okay. Everyone hear that? Just make sure that everyone hear that clarification. You want to repeat that, Mr. Hutt, a little louder for the folks in the back? Because I don't think everybody heard you.
Absolutely. The applicants do no longer seek to crush concrete or process concrete, take large chunks of concrete and turn it into the concrete dust that is used for base material for the roads. When I get to this in the site plan, you'll see where that used to be on the site and also where the mulch processing portion of the site was, and that is not going to occur on the site anymore either.
Okay, thank you.
As I said, I wanted to begin by saying what this application was not about, which is sort of an unusual place to start. But I also wanted to deal with some of the misinformation that has been spread about tonight's application. That has occurred in several mediums. There's been print, there's been flyers, there's been statements on the radio, there's been social media. And I just wanted to highlight two examples of that. First, there's been statements and written documents talking about the fact that this property has a quote-unquote history with DENREC's Environmental Crimes Unit. I believe that the proof that these folks are claiming is a FOIA, looks like a FOIA request that was filed with DENREC that asked for a list of all complaints. And frankly, I think if you look in the online packet, you would see the response that someone received to that. And there are 7 items that are listed as complaints that DENREC received. But of course, those are complaints that were lodged with DENREC. It doesn't mean that there was any type of environmental crime that was committed or found. And in fact, it doesn't mean that there was notice of a violation sent to the property owner. It doesn't mean that there was a charge assessed, a fine assessed to those individuals. And frankly, I don't think this is any different than any other agency that exists out there. I'd imagine Mr. Whitehouse's office and their staff would lodge a complaint if it was filed with his office properly. I guess the best example would be this: if 5 of my neighbors called and lodged a complaint about my use of my property in Sussex County, I imagine that Mr. Whitehouse's staff would document that they received 5 complaints about whatever it was, noise or whatever that happened to be. But of course, that doesn't mean that I received a notice of violation. It doesn't mean that I received any of those things, that the constable was sent. It would not mean also that my history has a history of, that my property rather has a history of zoning violations. Instead, it would mean that my property has a history of neighbors complaining. That's the exact case with the first 5 items that are on that list. When you look at that list, the first 5 items, excuse me, DENREC did not contact the property owner and provide a notice of violation. There was no charge assessed against Howard L. Ritter and Sons. No violation, no fine. The last 2 items on that list are described on the list itself as a permit check and public notice or public information. And that was a site visit conducted by DENREC at the request of neighbors. And that report, Mr. Whitehouse, as indicated, is in the record. And there was a couple of minor violations, a permit that needed to be applied for, all of which were promptly complied with by the applicant. But certainly one permit check does not create a history with the DENREC's Environmental Crimes Unit. The second example of misinformation is there's a statement that's been made that Susan Ritter, one of the principals of the corporation, and it's very specific. It says that on March 18th, 2021, she stated that there was a discharge, an industrial discharge to Gossley Creek had occurred. That is not true, and it appears that that is based upon, because it's, again, within the materials that are within the online packet, it appears that that's a reference to the NOI stormwater discharge application that Howard L. Ritter and Sons filed with DENREC as part of that permitting process that we were just discussing. And like almost every application universally, as you can imagine, there are boxes that name, address. One of those boxes says discharges to : and what was filled in on that box is 2 on-site ponds and Gossley Creek. But that's just identifying where the stormwater for this site ultimately discharges to. In the parlance that this commission uses, the outfall. It doesn't mean that there was an industrial discharge to Gossley Creek. At no time did anyone for the Ritters ever say we had an industrial discharge to Gossley Creek, and they wouldn't have said that because it hasn't occurred. And again, to be clear, there are no DENREC notices of violation. There are no charges that have been filed by DENREC. If you have an environmental crime, there actually is an arraignment, and none of those things have occurred. No fines have been assessed. And I wanted to begin this evening by setting the record straight on those couple of matters so that the application is not unfairly or incorrectly tarnished from the outset. And as a very brief aside, I would note that even though this operation is not going to continue, these types of operations in Sussex County are needed, and it's unfortunate that the closest ones to many of the locations within the Henlopen Transportation Improvement District are going to lie in Georgetown. If someone needs to process concrete, they're most likely going to have to travel to Georgetown, have it processed, and then bring it back as a base material. And that is going to occur more and more as DelDOT now allows that material that comes from crushing concrete to be a substitute for what used to be required to be a stone-based material, because that stone has become very hard to get. That what's produced by recycling or reprocessing concrete is now authorized by DelDOT to be used. And so it is unfortunate that this will no longer be sort of centered within that Henlopen Transportation Improvement District as part of the operations that were occurring at the Ritters. But again, that's as planners, maybe there can be something done to help that in the long term. Having said all of that, I want to return to the application that is in front of the Planning Commission tonight, which again is to permit by conditional use the existing historical sale of landscaping materials and products. The history of this, and I'm going to ask Mr. Davidson if he could go to the second to last slide. The history of this site, and as you know, I always enjoy the history of almost all real property, and this one has a good history. In the 1940s, the borrow pit operations began, and probably the easiest way to think of this is up in the upper left-hand corner of the screen. The first aerial photography you see there is from 1937, and you can see the property is outlined in red. There is nothing on the property. There is not even the beginning of a borrow pit. It is simply agricultural lands. And on every one of these, the current Sussex County tax map has been overlain. But as you can see, if you look past the tax parcels, Sussex County in 1937 was pretty much primarily agricultural, if not almost exclusively agricultural in that photograph. The next slide over is from 1954, and in the I'll call it the southwest corner of the site, you can see the beginning of the borrow pit activities that are occurring on the site. And you can again see that it continues to be surrounded by farmland. You can see the next image is 1961. Those borrow activities from the site have continued to increase. The next photograph, the upper right-hand corner, is 1968. And again, you can see the expansion of the borrow pit activities on this property. And I'm going to pause on that photograph for a moment because the Ritters, actually Howard L. Ritter and Sons, the business itself began in 1975. They were not the initial people who started the borrow pit. That was done by others. But they began leasing the property and operating their business in 1975. And that business did include operating the borrow pit, but also selling items that came to the site, such as stone and mulch and those types of activities as early as 1975. And I note this because I know I've presented several borrow pit applications, and part of your code on borrow pits and the special conditions for those is that site materials cannot be brought to them. And all of the materials that it needs to leave the site, it needs to be mined from the site and leave. And so that is unusual that you have a site that is doing both things. It's importing certain stones and mulches, but also exporting the mined materials. But that is what has been occurring for the Ritters since 1975. As you probably saw in the information, Howard L. Ritter and Sons was incorporated in 1976 and bought the property that had been leasing in 1979. If we move down to the next row of pictures, the first picture is from 1977. And again, you can just, it's a darker picture, but you can still see the expansion of the borrow pit. When you move over to the next photograph, that is from 1989. And this is actually the beginning of the development along Plantations Road. You can see the Plantations community itself, what I think some people refer to as Plantations West, is being developed a little bit to the east of this property. As you move forward, the next photograph is 1992, and then the bottom right-hand corner of the page is 1997. Again, you can continue to see the expansion of the borrow pit. And if we go to the next slide, the upper left-hand corner is 2002, and you can recognize that it's no longer the ghost images of the tax map aerial overlay. There has been, by this point in time, quite a bit of growth in the area. As you can see, all of the housing, residential housing that exists in this area. The next photographs, again, continue on, 2007, and then 2012 is in the upper right-hand corner of the screen, and that's starting to look actually what you would see if you drove to the site today. Below that, you have 2017 and 2021, again, very current aerial imagery, and it also, again, shows the growth that has occurred along Plantations Road and in that corridor. So the borrow pit itself has been in existence since the 1940s, and the Ritters themselves, the individuals sitting here, have been selling not only the borrow materials, but the stone, mulch, and those other landscaping materials since they began their business in 1975. The customers who patronize their facility have included the state of Delaware, Sussex County, most of the municipalities on the eastern side of the county, hundreds of local businesses, and of course thousands of residents and property owners in Sussex County itself. With that quick historical background, I did want to describe the property itself in a little more detail. The property totals a little more than 50 acres. If we can go to one of the aerial images. Has a little more than 50 acres, and as you can see, there's primarily two ponds that have been excavated on the site as part of the borrow pit operations. I think everyone's familiar with this, but of course access to this site is along Ritter Lake Road, which intersects with Plantations Road, where Mr. Davidson has the cursor. As is the case with all applications of this nature, a service level evaluation request was filed with DelDOT, and the report that it returned indicated that this proposed conditional use would have a diminutive traffic impact. And I'm not trying to confuse anyone, but when DelDOT responded, the operations that are not going to be done anymore, the concrete crushing and the mulch operations, were part of that consideration. So there are even less operations, and frankly, DelDOT, I don't believe, has a term under its memorandum of understanding with Sussex County that has less traffic impact than the term diminutive on that spectrum. As the Commission knows, that means that it represents less than 50 vehicle trips per day. Plantations Road, that Ritter Lake Road intersects, is within Phase 1 of DelDOT's planned improvements on Plantations Road, which I believe are imminent. If we can move to the next slide, actually the one after that, and then the one after that. The property is zoned AR1, and everything on the image that Mr. Davidson is highlighting, everything that's not shaded in any particular color is AR1, so the properties to the north, the west, and the south are also AR1. As you can see, the properties to the east are zoned MR, medium density residential. There have been a number, you can see it in the bottom of the screen where the cursor is, and then on the page that follows this, there have been a number of conditional uses within this greater area. I'm not going to detail all those. The staff report that was completed and put in the file identifies a whole page of them on a spreadsheet. The only thing I would note is that two of those applications are for the exact same thing that we're here for tonight. Over the course of the past decade or so, Stokely Materials has had two applications for essentially this same exact operation. As you may recall, Stokely Materials was on one side of the road and then had a conditional use to move to the other side of the road. The 2019 2045 future land use map that's in the 2019 comprehensive plan shows the area as being within the coastal area, which, as you know, is one of the county's growth areas. And as you can see, the property is shaded in green, but of course everything that surrounds this property is also within the coastal area. On the 2020 state strategies maps to the right, you can see that the property is mostly within a level 2 area, with some of the second pond to the rear of the site being in a level 3 area. And as the Commission is familiar, level 2 areas are places where the state anticipates growth in the near term. To quickly help orient everyone to the property and its immediate neighbors, the immediate neighbor to the east is a wastewater treatment facility that was formerly operated by Tidewater Environmental Services, Inc., or TESI, and of course is now under the care and control of Artesian. Immediately south of that wastewater treatment facility is a portion of the plantations. Actually, it's where the condominiums are located in the original plantations development. And then along what I'll call the southern boundary, thank you, Mr. Davison, you can see that this is an agricultural area and then a wooded area with a single-family residence in that area. If you move to the western side of the property, there are more agricultural lands. And then what I'll call the north side, and it's probably more correctly the northwest side, but there are 2 single-family residential communities that are there, Morning View and then a newer community, Maritima. Water on this is provided by an on-site well, and for sanitary sewer service throughout the history of the property, it has been porta-johns or porta-potties. In the materials that were submitted and are part of the record, you saw probably that the Sussex County Engineering Department identifies this area as being within a Tier 2 service area and indicated that there is capacity within the system for this property, and also provided the information if the property owner wanted to be annexed into the Sussex County's unified sanitary sewer system. One of the good features about this application is that no one, whether you're a planning commission member or county council ultimately, or even the individuals who are interested, has to wonder what this is going to look like if county council acts favorably on the application, because it's going to look like it does presently because the use has existed for decades. I'd like to take a brief moment and look at the site plan that you can see. As you come down Ritter Lake Road, the first thing you would come to is a handful of storage bins that exist at the end of Ritter Lake Road, which are more overflow or surplus. The primary components of the business, you would continue down and go to where the cursor is located towards, I'll call it the rear of the site, where there are many more storage bins that have the different types of stone and mulch and other landscaping products. And there's a blow up to the right, which is slightly clearer, I think, than the other image, that shows the various buildings and structures. You can see the scale that's used to weigh the materials, and then the various, again, storage buildings and buildings that are used as part of the operation. All of these would remain where they are. As you can see, based on the arrows, where the primary component of this business is located, the closest residential dwellings would be the plantation condominiums that I referenced, and those are about 300 feet away. The residence to the southwest, it is at least 800 feet away from those operations. And then the community to the north, Morning View and Maritima, are a distance of 1,000 feet, again, from that storage bin area where these activities would be occurring. The Planning Commission is very familiar with the purpose of a conditional use, but very briefly, those are uses of a public or semi-public character that require the exercise of planning judgment regarding location and site plan. And of course, part of that analysis, like all applications that the Planning Commission considers, is whether or not that application promotes and is desirable for the general convenience, orderly growth, prosperity, and welfare of the county. The historic use of this site and these materials by thousands of consumers, from governmental bodies to businesses and homeowners, certainly shows the public or semi-public character of the uses. And these are not uses that are unfamiliar to anyone on the commission or anyone here in this room this evening, as there are many of these that exist, including places like McCarthy Stone, the Rock Pile, Stokely Materials, Mr. Mulch, and of course these are located throughout various areas of Sussex County. Again, the fundamental need and use for these materials demonstrates their semi-public or public character, and with some proposed conditions that I will hand out to Mr. Whitehouse here momentarily. Those site plan considerations can, of course, address any concerns that exist from members of the public. Two of those conditions that I wanted to highlight this evening are the first two conditions. And I highlight those for two reasons. The first reason is because the first condition states that this conditional use shall be limited to landscaping material storage and sales, it being noted that the pre-existing nonconforming borrow pit operations continue. And again, that's just to acknowledge the fact that there is a pre-existing nonconforming borrow pit on the site. The second proposed condition, which I think is of utmost importance to most of the public, is condition B, which says there shall be no manufacturing that shall occur on the site. This prohibition includes the crushing, shredding, or grinding of any materials, and also includes the dyeing of mulch or similar materials. And while the word concrete was not used in that, the term was broader. It says any materials. There shall be no crushing, shredding, or grinding. The various conditions that exist, conditions C through J, are typical Planning Commission conditions for your consideration. Before I conclude, I did want to reference the significant number of letters and emails in support. As you know, it's somewhat unusual. People are more apt to complain than they are to support. And so it is unusual when you have that number of letters in support. And I think that the tone of those letters said a lot about this. One of the statements was that I saw in one of the letters or emails is, this business is an economic engine for our community and shouldn't be impeded but help to grow and prosper. Another statement was that this is an integral part of the local business community here in Sussex County and has been for decades. Another email described it as a local, loyal business. And I'm a firm believer of the common sense notion that actions speak louder than words. And that's exactly what the Ritters did. When the neighbors protested the concrete crushing and the shredding and grinding of the mulch, they revised their application, even though they had been there for decades before those people came to the area. But they agreed to discontinue a very profitable part of their business, the processing of those materials. The Ritter family would ask that the Planning Commission recommend approval of this conditional use with the proposed conditions that have been submitted, so that this business can continue on the property and continue to provide these valuable services to all of the various consumers, whether they be those governmental agencies, businesses, or property owners in the area. That concludes my presentation. Certainly myself, Mr. Davidson, and the Ritters are happy to answer any questions that members of the commission or staff may have.
All right, we thank you, Mr. Hutt. We'll see if anyone on the commission has any questions for you, and we'll start with Ms. Hoy Stevenson.
Nope.
Okay. Ms. Coppin? No questions. Ms. Wingate?
I don't really have any questions. I just would like to make a couple comments that I know that there is a great need for these services, because I have purchased things from them for many times myself. And I think that they're great neighbors for them, having pulled the original application. So that's all I have.
Okay.
No questions, but I agree with Commissioner Wingate.
I do too.
Good. Very good. Staff?
None for me, thanks.
Staff over here?
No, sir.
Okay. Counsel? All right. Mr. Trott, we'll take a seat nearby. We'll see if there's anyone here that has an interest in your application. Is there anyone here that would like to speak in favor of conditional use number 2327, Howard L. Ritter and Sons Incorporated? In favor? Yes, sir. Come on up.
I just had knee surgery, so it's a little.
Yeah, I'm sure you've been sitting a long time.
Well, we can tolerate you.
All right.
Anyway, my name is Michael Robertson. I live on Plantation Road. My credentials is I retired from the U.S. government. I took care of all surplus, excess, precious metals, and hazardous waste. One of the things that kind of set me off on this whole thing, there's a business that's been there close to 50 years with no complaints. DENREC does not go around and check on each individual business. They don't do that. I've had some very different conversations with them over the years over things that they screwed up. In this case, we have a local contractor who purchased the ground right there next to back, right up to it. Well, we've seen this before with chicken houses, sewer plants, and the most recent one, I was talking to a friend of mine from the Department of Agriculture. Can't you get that farmer to plant something different in there because all the leaves blow over in my yard? You know, our answer was, well, go put some mulch over it. It's good for your lawn. But you drive in that business, there's nary a piece of trash, dirt, anything blowing around. As far as what I saw go out in some flyers, some very, very bad information. They were talking about sodium hydroxide. Sodium hydroxide, for those of you who don't know, goes into concrete. By itself in a gallon jar, yes, it will burn the daylights out of you. And it will do such in a concrete too. But once it's in the concrete, it's like linoleum that has asbestos in it. It's contained in there. Once that burns off, it's gone. There's no runoff of that. The only runoff from concrete is lime. No water samples were ever taken. They were talking about the silica particulates that were possibly going far down as Henlopen Landing. Now, I find that pretty hard to believe because the silicate is pretty small, very light. The actual metric weight of it doesn't even show on a scale. And things like that infuriate people. You know, if you're going to build next to the sewer plant, you've got to expect a smell. But from here, you know, he was doing a really good service because the amount of concrete that we're developing and producing here to build homes, businesses, and what have you is substantial. But these trucks do have a runoff. Somewhere, from what I hear over by Atlantic Concrete, it's going to rear its head to you again because it's not in my backyard. But I am very much in favor of Mr. Ritter being able to return to his business. I think it was a little heavy-handed to shut him down completely with little or no information from DENREC or no guidance from them. But I appreciate your time. Thank you very much, and I hope you can let him return to business. Thank you.
Well, thank you. Anyone else like to speak in favor? Okay, is there anyone here? Are you coming up? Okay.
My name's John Davidson. I'm a local contractor. Been in business for 47 years. I've dealt with Ritters since the late 1970s. They're like a nucleus for a lot of small businesses in the area. They're really needed. You know, I'm not trying to repeat what other people have been saying, be repetitive or anything, but it's something that is really needed, and they've been here a long time. They were here first. So.
All right. Thank you. Okay. Anyone else like to speak in favor? All right. Is there anyone here that would like to speak in opposition to conditional use number 2327?
Good evening. My name is Chris Clemson. I'm with the law firm Gordon Fernandez and Mammarella, and I'm here on behalf of Aurora Homes, who is the developer of the Maritima community, which is directly northwest to the subject property.
Mr. Clemson,
Yes.
you remember the Delaware Bar?
I am.
And your bar number is?
6539.
Welcome to Sussex County Planning and Zoning.
Thanks so
You
much.
may continue.
While I definitely do appreciate Mr. Hutt's explanation and the Ritter's amendment to their application to remove, or to at least provide that they'll not engage in any crushing of concrete as part of its borrow pit operation, I guess, you know, that does ease the chief concern of my client and several of the members of the surrounding community here today, and as this commission I'm sure appreciates. I don't necessarily have an objection to their application with regards to the proposed sale and storage of landscaping materials. I would just request that the commission supplement Mr. Hutt's conditions to provide, namely that any crushing or any, that it does specifically include concrete. I know it says all materials, but I'm more focused on primarily pre-existing concrete that currently exists within the borrowing site, within the borrowing pit. So my concern is that while he is able to engage in the pre-existing non-conforming borrow pit operations, that some of the pre-existing concrete within and surrounding that borrow pit and the ponds therein might require the excavation of that concrete, which would basically give rise to the sort of health concerns and the nuisance concerns of the members of the surrounding community. So I would ask that the commission sort of maybe look into that fact as to whether there's an existence of any pre-existing concrete and whether the excavation of that concrete will be required by whatever permit, conditional use permit that the commission decides to give. Further, I'd request that the commission also consider some additional conditions that they deem appropriate for the additional, some additional vegetation and some buffers to these surrounding communities above the minimum requirements outlined in section 11572B of the code with respect to these operations in the borrowing pit. And as Mr. Hutt had mentioned, as a level 2 investment area surrounded by a level 1 investment area to the north, which also lies within a coastal area as part of the comprehensive plan of the county. Any industrial use should be significantly limited to protect the interests of the community. And that is my presentation. So I'll take any questions.
I do have one question.
Sure.
What community are you representing?
Maritima, it's the one directly to the northwest.
And when was that done?
That was in, I have to look at the exact date. I have that information here.
In the last 5 years.
Yeah,
Okay.
it's a fairly recent community and there's
Okay.
still some sales ongoing.
That's all. That's all. Thank you.
Perfect, thank you so much.
Anything else? Anyone? All right, Mr. Clemson, thank you for your presentation.
Thank you.
Okay, anyone else like to speak in opposition? Yes, sir.
Thank you, sir. My name is Stephen Dunn. I reside in Maritima. Good evening, ladies and gentlemen. Just a 60-second brief synopsis of my opinion here. I support the conditional use application of this local business. Ran a local construction business myself many years ago in landscaping. And again, I support it with reasonable conditions. And basically, I live about 250 feet away, right there on Ritter Lake Drive, as you can see. And I'm very concerned about the heavy-duty traffic going in and out. There'll be cement trucks, heavy-duty trucks. There'll be a lot of dust and dirt being kicked up. And I'm concerned about it billowing out on Maritima and also Morning View on the northwest section of the property. In fact, 6 Maritima homes are parallel to Ritter Lake Drive, and the buffer is about 5 or 10 feet. It's very, very narrow. And they're going to face the brunt of this dust and dirt in their back doors and their kitchen windows. I think there needs to be a reasonable setback, maybe 150, 200 feet from the property line of Maritima, Morning View, and less so plantations. A setback will operate as a natural buffer and reduce the nuisance of dust, dirt, as well as noise. There also needs to be an industrial water-based sprayer system that will also reduce dust and dirt from commercial trucks passing by the residential homes only a few feet away. A fence is another reasonable condition. Atlantic Concrete has all these conditions that I just mentioned: irrigation system, fence, sprayer. They're a good neighbor of 5 Points as far as I can see, and that alleviates a lot of the concerns of the 5 Points residents, not all, but a lot of the concerns because they have a fence, a sprayer system, and other things. I just requested the board impose these conditions to prohibit. Well, I should also, we just found out, obviously, very recently that concrete crushing was no longer on the table. But I requested the board impose a condition that prohibits concrete crushing, jackhammering, and composting of any kind, given the low proximity to these residential communities. And I'll remind the board that there's a 1979 deed restriction that prohibits landfill, dump, or related use on this property, and we just want to make sure that's not violated. So with these reasonable conditions, I support this application.
All right, sir.
Thank you, sir.
I have a big question here. You just said there's a 5-foot buffer. Shouldn't Maritima have a bigger buffer than that?
Yeah, and why don't they have landscape on their plan for their approved
There
plan?
would be, it's new enough that there should have been that perimeter buffer that was established.
That maybe that developer should be doing already.
Yeah.
We recently inspected that buffer as part of the Phase 1 landscaping. Phase 2 of Maritima is under construction. I'm not sure of the status of the buffer for Phase 2, but Phase 1 is the southernmost part here, and that was inspected.
So their buffer is the 20,
It's not 30, I think it's 20 on this development by each year of approval. There's no annotation here, but we have inspected Phase 1 because I know there was a bond release request within the last 12 months.
And Ms. Wiggett, if I could just address your point, naturally, this development was approved by planning and zoning, and it is very close to the Ritter complex. That was not necessarily the developer's fault that it was approved, but it was approved, and we just want to have a good neighbor relationship, even though we're so close to one another. And that's why these natural buffers, spray system, and a fence are so important.
Their buffer was not in compliance?
Staff just notifies us your buffer is not in compliance.
I represent the residents, not the developer.
Right, but as a
Right.
resident of that community, you can go back to your developer.
Yeah.
That's your right. It shouldn't be put on the Ritters because their property was there first.
yeah.
Yeah, the staff.
I was going to say, I'm pretty sure we're going to take care of that. So,
But again, we're just concerned about the heavy traffic coming up and down the road,
Which was already there.
Right.
when you
which was
bought it.
already there.
Yeah.
And the development was approved by PNC, and we're in this position now, and we're just looking for some reasonable compromise.
Okay, I just want to bring up something that he just said, because I bring this up every now and then, and people look at me like I have two heads, that people are going to come in here and say, this was approved by you. What were you thinking?
Yeah.
So, this is something we need to start considering.
But they also purchased it knowing that it was already there.
Exactly. And their development.
That's the choice.
Didn't provide the proper buffer.
Yeah, and there's another element of it too, is that the developer's the one that designed it in that way, knowing that Ritters were right next door.
That's right.
You know, we only have, as I've talked about before, as a commission, we have to take into account neighboring adjacent properties, but if it complies, you know, it's not like we can say you can't develop there next to Ritters. I mean, they're the ones that designed it, so I don't know that, I follow that line of reasoning completely, that it was approved by planning and zoning, therefore now planning and zoning has to impose conditions on the Ritters. It was approved based on a plan that was submitted by the developer of your development, and then that developer sold everybody lots next to where the Ritters project is.
It's kind of like if you had if you bought a piece of land and you built your house, and the chicken house was already on the neighboring property, and you built your house, right along the line as close as you could get, and the exhaust fans blew out the back of the chicken house towards your house. You can't come back later and say, we really think this farmer ought to tear that chicken house down or put a wall up.
Well, Ms. Hopkins, I just mentioned Atlantic Concrete is the first chicken house over at 5 Points before 5 Points existed. And Atlantic Concrete voluntarily put in the spray system, the fence, and other environmental controls to be a good neighbor. And that's all we expect to.
Well, thank you.
Thank you, sir. Ladies.
yes, ma'am.
Oh, I'd like to speak in opposition.
Yeah, I'm recognizing you. Please come forward.
Members of the Commission, good evening. My name is Andy Bueller, and I am a resident of Maritima. I've lived there for 18 months. And I'm here to give you testimony of what it's like to live in an adjacent neighborhood. I'm also a real estate agent. So I've been licensed in Delaware for over a decade, actually. To your point, when a business is presented as sand and gravel, a borrow pit, that's one thing. When you move in and basically the property next door begins a concrete crushing operation, I want to tell you what it's like to live there.
Well, I'm going
Was
to stop you
off the
right
table.
there. I'm going to
That's
stop
off
you
the table.
right there. concrete crushing is off the table.
Okay.
We already know what it's like. All of us have seen concrete crushing operations. We really don't need the tutorial. So I'm going to ask you to get to your objection to the application that is in front of us, please.
Yes, I will testify that there have been multiple incidences of noise coming from trucks and heavy equipment that literally will wake you up. And I'm a sound sleeper. I will give you testimony that there is ground-shaking disruptions. Of late, the last one was the first week of June. I have it on my cell phone. Ground-shattering disruptions that actually shook the glasses and dishes in my kitchen cabinets. Okay? They were shaking and rattling. Lastly, I have seen multiple sightings of garbage trucks going back and forth on that property. Now, I'm sorry, but that's not a sand and gravel borrow pit. That is, and back to the dumping or the violations, the DNREC violations. I don't think DNREC makes complaints on record if they're of no concern.
Could you tell us specifically which DNREC violations you're talking about?
I think there's 7. There's dumping, of which I'm telling you, I see garbage trucks. You know, the bright green garbage trucks going back and forth.
Now, when you say garbage trucks, you mean like a roll-off can?
I'm not talking like
waste management.
I'm talking garbage trucks.
You're suggesting they're dumping garbage back there?
I don't know.
Are they using roll-off cans to come get materials?
I do not know but what I'm saying is before this goes any further, these things need to be investigated. I am pro-business. I am pro-small business. I want to see the Ritters thrive. I understand that they serve the community and their needs, but you know what? We are all residentially zoned, and I also would like to, as a licensed realtor, I want to bring up a legal point in disclosure law.
That would have been on your seller, though.
Pardon me?
A disclosure would have been on your seller. That's not an issue for Sussex County.
If he knew. But getting to my point on moving forward with the sellers and the property owners that are adjacent, that are aware of the noise, the dust, the environmental hazards that are before us here, we now know what we know simply by virtue of these hearings and public notice and us having this discussion. We are on record now. So if I was to represent a seller in Plantations or Maritima, and they would complain of the nuisance, the noise nuisance, of which I am witness to, having lived there, if they don't disclose, and you understand, they are in a heap of trouble if they do not disclose. You can come back as a buyer on a seller and say, look, we didn't know this stuff was going on. We didn't know dumping was going on. What about composting?
You don't know that
Actually,
dumping's going
you
on.
don't
I
know
do
that.
not know.
Actually, you do
Shouldn't say
not
that.
know that today, and you're not the only licensed realtor in the room. There's a few more up here. Okay.
Good.
So,
But do you understand what I'm talking about?
I know exactly what you're talking about, but it turns on knowledge. You are guessing. You're saying, I see trucks, and I don't know what's in them. You don't know, so you have nothing to disclose. Okay, and we're not here to argue disclosure. And I want you to please tell us what your objection to this application is, because you are really on some very broad topics right now that are beyond the scope of what we're doing here.
Are they not of concern, though, with all due respect?
Ma'am, they're definitely of concern, but they're not a concern of this proceeding.
And let's keep in mind just one thing, too, for everybody here. We're not considering the borrow pit operations themselves. That's a legal nonconforming use of predated zoning, which means it's grandfathered. That is not the subject of these proceedings. The subject of these proceedings is limited to what Mr. Hutt talked about as the landscaping material sales and storage on the site without any concrete crushing or stone crushing or rock crushing or mulch or grinding or shredding or anything.
So that is no hazardous.
So that's the
Okay. I'll tell you exactly for the reasons that I tried to explain earlier. They recently amended, I believe as of October 24th, they amended their application. But they have failed to disclose details pertaining to the related outdoor products. What is related outdoor products? Is that smelly composting? And another thing
have you been here all evening?
Yes, I have.
Did you hear the presentation?
I did.
Because he described exactly what those materials were.
He said landscape materials, or outdoor. He didn't get into it.
And prior to that, he enumerated what those items were and then said, in order to keep from having to repeat the list every time, I will refer to them as landscaping materials. So that information's in the record, man.
Landscape materials can include compost.
Well, that was not on the list of things that he gave us, so we can only assume that the descriptor that he chose, and it let us know that he was choosing, and also told us specifically what it referred to, which was his list of items, that, for the purposes of this hearing, is landscape materials. That's what it is tonight. It's not anything else other than that. It's what they testified to. So, I mean, that's what's in the record.
Well, they also testified to, did they have a permit to crush concrete prior to them being shut down?
It's not an issue for this hearing, ma'am. And by the way, the 7 items that you referred to were also investigated and explained. Okay, that is also in the record. So
I mean, I think their mistake is that before you all and a whole bunch of other people moved in, when they were crushing concrete years and years and years ago, that they failed to go ahead and get it legalized.
There was a lapse in permit, many of them.
Well, they probably thought that they were grandfathered in. I mean,
Well, the permit requirements have changed, too. So it's almost a nightmare to keep up with the permits as they are ever changing.
You've got a company that's...
It predated, the activity very well could have predated the requirement for a permit,
That's right.
too. So,
But is this not under the coastal area, under our comprehensive use program, which was just enacted in 2018? As a coastal area, doesn't that provide protection, some environmental protection, more so than other non-coastal areas? You guys were the ones that...
Being in the coastal area, we could certainly say that we have a great need for their service, for what they're
And
providing.
coastal area designation, too, that's a land use overlay. That's not per se an environmental classification of an area of Sussex County. It's more of a designation in terms of what's permitted and not permitted from land use and development.
Okay.
So the dirt pit that's non-negotiable. That's not a topic of discussion. That's approved. The only thing they're asking for is to continue to sell stone and mulch and soil related type items like you would see at Stokely Materials or whatever. They're just and for which they have been doing for years and years and years. Because they failed to get the crushing item taken care of 20 years ago, they've conceded that, you know what, shame on us, we should have done that, 20 years ago. You'd be hearing that crusher run, 3 or 4 times a year when they come in to do all the crushing. But they failed, and they've thrown the towel in, and they've said, all we want to do is just, we already have a pit. We just
We're
want
trying to be good neighbors.
We want to continue to, to sell our stone and mulch and soil.
Well, I say no, and I'll tell you why. Simply because they have not been a good neighbor. For 18 months, they have not been a good neighbor at all. And I'm sorry, I want to trust them, but if you can assure me and other residents that they will be a good neighbor and that they will comply to their permitting, zoning, environmental conditions, and the safety of the welfare of their neighbors and residential areas around them, because we were all residential. They were never, like everybody says, oh, they were grandfathered in. Well, it was always residential agriculture. It was always residential. So, I want to trust them, but based on the past history, you have to question. I do. I want to be able to take them for their word, but I live there, and I will tell you, they rattle the dishes.
That's still going to happen.
In my, really?
Yeah,
the ground shakes.
The trucks
shakes.
Coming and going are going to continue.
The trucks have been coming. Yeah, the trucks
That's not trucks, sir. With all due respect.
What's causing the rattling?
I don't know. That's like massive heavy equipment.
Really?
That is stuff I've never heard of before. Okay? This is, I'm telling you, and do you think it's like I should be seeing garbage trucks going in and out of there? Really? No. That's wrong.
Okay. All right. Thank you very much. Anyone else like to speak in opposition?
Hi. How are you?
Good.
My name is Tagrid Maher, and we are going to be future residents at Maritima.
Okay.
And our lot is right there on the corner of Four Leaf and Lucky Charm Lane. So my view is going to be of that burrow pit. I didn't know. I'm sorry. We're new here. We're just inexperienced. We want to build our retirement home. We've worked very, very hard, saved money to build this home. We love the ocean. And we thought, well, this would be the perfect place that we can afford. But now we're learning that there's this burrow pit. And I'm sorry, I don't even know what a burrow pit is. I mean, I look at it and I just see a big hole, an ugly big hole. And it's all like, I don't know, brown.
And you never saw that until...
Seriously, yes, I'm sorry. But I don't oppose their business as long as what their lawyers described, because my first concern was the concrete crushing. But now Andy's saying all the traffic. Well, the concrete crushing is gone, and that's fine. That's good. That's very commendable of them. And I would say for me, and my concern is that they support, or the zoning board backs up what Mr. Dunn has recommended as an environmental remediation to be a good neighbor. Okay. And I think if, we work together, they keep the traffic at a minimum, and maybe they can put some kind of a condition on what kind of traffic or size of trucks can come, and they make sure that the burrow pit does not fill in with dumping. Okay. I think we could be good neighbors.
All right.
Okay?
Okay.
Thank you for listening to me.
Yes, ma'am. Thank you. Okay. Who's next?
Hi, I'm Chris Carper. I'm a resident in Maritima. And I just want to really say that I really appreciate them taking the concrete crushing off the table. That is good neighbor. Okay. That was the biggest opposition with their business. Right. Sand and stone is what they do. Yep. Landscaping products is what they do. Yep. But sitting here learning now, as far as the buffer, whose responsibility it is for that buffer between Ritter and Maritima, because my house is the house that's closest to Ritter, which is next to the buffer. I bought that house knowing Ritter was there. I really didn't understand and know what the concrete crushing was at that time. My mistake. I still bought there.
It's gone. So it doesn't
right.
matter.
So I own up to it, you know.
Good.
But the responsibility of that buffer, if it is Scott Daly and Maritima, I want it done. So you said you guys were going to look into that. Please do, because it's important that us being Maritima residents and Scott Daly not even present goes to show you something. So if the buffer I would love, because my house is right next to it. So take action on that, please.
Okay.
Thank you.
Yes, ma'am. Thank you. Okay, who's next?
I can quickly answer, Mr.
Yes,
Chairman,
okay,
that
go ahead.
question. So we have inspected the 20-foot buffer in Maritima. Our last inspection was in March of this year for Phase 1, which is the southern part here. Phase 2 is not complete yet. They intend to build the buffer as the homes are graded and completed. And the developer has been working with staff as we monitor that, as building permits are linked to completion of the buffer. But the owner of record for the buffer area is now Red Clover Walk LLC. So that's who we will be working with. So.
Okay, thank you. All right. Anyone else like to speak in opposition? Going once, going twice? Okay. Operator, is there anyone standing by electronically who would like to speak in favor of or in opposition to conditional use number 2327, Howard L. Ritter and Sons Incorporated?
At this time, there is currently no one on the line.
All right. Anyone on the commission have any further questions or comments? Okay. All right. Well, before we close the public hearing, I just want to remind you that it's very normal and natural for you to want to get up and start talking. Believe it or not, we have another public hearing, so I'm going to ask you to, if you're choosing to leave, just leave quietly. But we will close the public hearing. We do invite you to remain with us the rest of the evening to see if we make a decision. Thank you. Our next public hearing